Hello, everyone. Dr. Lisa Fost here with DiversifyRx. We're going to take care of some of the housekeeping first, and then we're going to jump right on into the content. If you're not familiar with the GoToWebinar platform, on the right-hand side of the screen, you'll be able to mute and unmute yourself if needed. Typically, we don't unmute attendees. Please enter your comments and questions into the box, though. We do have a lovely moderator, Ms. Heather Haro, who will be monitoring all of the questions and comments in that box. So we really do want this to be a lively discussion between the panelists and the attendees. So please feel free to put any and all questions right in there. And this session will be recorded. Everybody who registered, whether you attended or not, will automatically get that recording sent to your inbox. So Christmas came early for independent pharmacy. I'm very excited. I'm sure many of you are optimistic. And so we put together this panel with some experts on this very subject. We've got Nathan Mayer, Miguel Rodriguez, and Scott Newman. So I'll let everybody go around and introduce themselves. Let's do it in a little bit of alphabetical order. So Nathan, why don't you go ahead and go first?
Yeah, absolutely. Yeah, thanks for having me here today. My name is Nathan. I'm a independent pharmacy owner. I'm in the Ann Arbor, Michigan area, and also a board member of Pharmacists United for Truth and Transparency. And we've also started a chapter here in Michigan. So the president of the PUTT Michigan chapter.
Awesome, thank you much. Miguel, you're up next.
Yeah, thanks, Lisa. My name is Miguel Rodriguez. I'm general counsel for American Pharmacies. We're a buying cooperative with stores across the country. We have hundreds of independent pharmacy members, and so we have a very active advocacy practice. Michael Wright, who's our Vice President of Government Affairs, is extremely active in trying to pass the kind of legislation similar to the Arkansas law that Rutledge dealt with in states across the country. And so we take a really close look at what's happening in legislative affairs across the country. We've been successful in passing a lot of good bills in Texas and New Mexico and are expanding our reach. So this is a very important decision, and it's going to be a big boost to all of independent pharmacy. Thanks.
Awesome, thank you. And last but not least, certainly Scott.
Hi, Scott Newman with PUTT. Also own an independent pharmacy in Chesapeake, Virginia. Glad to be here. This is what I was just telling everybody, that I think we all had a little bit extra pep in our step this morning, so good times.
Yes, absolutely. I'll get your guys' initial first reactions in just a minute. I want to take just a moment and thank everybody for supporting not only this bill. This has been a fight. I remember a couple of years ago, we were taking donations and doing those kinds of things. Tonight's webinar, I just want to thank our supporters. So American Pharmacy, APRx. Miguel, I don't know if you want to say a few words about APRx, just what it is and what it does for independent pharmacies.
Yeah, we're a cooperative that is a buying cooperative for independent pharmacies. Our prime vendor is AmerisourceBergen. And so we're obviously focused on that role, but because all of our members are independent pharmacies and our board are all independent pharmacy owners, anything about independent pharmacy, anything that affects it, is really near and dear to our hearts. And our mission is really to support independent pharmacy owners in every way we can. So we have a reach across the country now. We've been growing fairly quickly across the country, and so some people maybe on the West Coast may not have heard about us except recently. We've started in Texas and expanded to the surrounding states, the Midwest and East Coast pretty much now. But yeah, we're very focused on anything that makes independent pharmacy tick, and are on top of troubles it's faced, and hopefully after this, some of the good news that's coming out now.
Yes, absolutely. Scott, you want to speak for PUTT?
Sure. Scott Newman again, with president of Pharmacies United for Truth and Transparency. Our board has grown a couple members in the last few months, because what we found is that since we're an all volunteer group of people that are really spending a lot of time in the advocacy fight, we just try to pick up people that are also willing to put the work in, and it's a full-time job. I'm not gonna lie, I don't get paid for it. I do it on behalf of independent pharmacy because I'm passionate about it, and I think that as an organization with less than a tenth of the membership that some of our national organizations have, we have a very large voice and a seat at the big boy table. So the reason why that is because we've got a great executive director and a terrific board that puts in the time and knows this industry better than probably anybody else.
I couldn't agree with that sentiment more. And then lastly, our supporter, Wellgistics. They're a technology supporter today. I am the Chief Revenue Officer of Wellgistics, along with the founder of DiversifyRx. And Wellgistics is an NABP accredited drug distributor that focuses on niche products. We aren't your primary wholesaler, and we're not even your secondary wholesaler. We only carry about 100 or so products, many of them exclusive to Wellgistics. We only sell to independent pharmacies, trying to give independent pharmacies that edge when it comes to product procurement. So, all right, let's dive into the content. What I'd like to get everybody first is, what was your initial reaction when you got that message or that text or that news alert? What was your face? What did you do? What happened when you saw that judgment come down from the Supreme Court? Who'd like to go first?
I'm happy to go first. First of all, my first reaction was already, like I was already had it in the back of my mind that we weren't going to hear any word, good or bad, until March at the soonest, maybe as late as June of next year. And for a decision to come out so soon blew me away. My second immediately after reaction was that it was a unanimous decision. All the justices agreed on the result. That blew me away. So I was not expecting a fully unanimous decision. After oral argument, I thought I saw some fault lines between them, but I was blown away. And then, of course, the victory was it's just, I don't know how to overstate how important it is. So that blew me away too. Unanimous victory. It's great.
Yeah, I was actually on a phone call with a couple of people when I saw it flash across my screen, and I think I was in the middle of talking, and I said, "Hold on, wait a minute," and I looked a little closer, and I was like, "Oh," and I was a little speechless for a moment, and then I was like, "Oh my gosh, you guys probably know nothing about this, but here's what just happened, and this is huge," and I would just immediately kind of got all flushed and all excited. So as Scott said, we all kind of woke up with a pep in our step, and my pep started at that very moment yesterday. So any other first reactions? Nathan, I know you're not on video, but all right, go ahead, Scott. Were you raising your hand? Oh, not hearing you, Scott.
Sorry, my remote. Yeah, so my first reaction was just like, you guys are already? Because, March was the soonest that we were thinking that we might hear something. And I was surprised by the unanimous vote, but I was also surprised by how broadly the response from the two justices was, which means a whole lot of stuff for us. And that part alone kind of blew me away, because everything up to that point was, well, this is going to, if they win, then we're going to make it a singular issue, and if we win, they're going to make it a singular issue. And no one really talked about if they had leveled such a broad decision in general, like their rationale between for why they made their decision. To me, was a big surprise.
Yeah. So Miguel, as the resident lawyer of our panel here, can you kind of break down what this case was about in some plain language? So, we all know it was kind of a fight for pharmacy, but I've talked to a lot of pharmacy owners and even chatted with some that didn't really quite understand what this case was about and what the verdict actually means. So can you break it down for us?
Yeah, I'll take a crack at that. when you hear the word ERISA law, it just automatically puts everybody on their heels thinking there's no way I'm going to understand a thing this is going to be about. But in simple terms, Arkansas passed a MAC reform bill all the way back in 2015. So this is 5 years ago, and that law has been in litigation in the courts against PCMA since then. So for the past 5 years, it's been in the courts. The MAC reform law is similar to some that have been passed across the country. We have one here in Texas that American Pharmacies had supported. But basically, update your MAC list regularly, make sure your MACs are reimbursing the pharmacy above acquisition cost, some of the typical provisions that other states have. So PCMA said that law could not be applied to employer-sponsored health plans, which is a huge amount of the healthcare market in this country are the health plans that employers provide to their employees. And so this MAC reform is inapplicable to employee health plans is what PCMA wanted, and they had won at the lower courts on appeal, on the first appeal, and then now to the Supreme Court. And the Supreme Court was going to, for the first time, as far as I know, really dealing with pharmacy benefit managers, a Supreme Court decision. So it's a once in a generation opportunity for the U.S. Supreme Court to deal with the PBM issue. And the way they decided is, as Scott mentioned, it's going to be either something great for the winning side and horrible for the losing side. And so the result of this, just to summarize the impact of this result applies not just to this Arkansas law, which was upheld, but to any other state law in any part of the country, not just MAC laws, but transaction fee prohibitions, post-adjudication fee prohibitions like GER, any other type of state law across the country that's on the books or that people are about to talk to their legislators about putting on the books for next year, those are all now open to enforcement to the widest variety of commercial claims, all commercial claims. And so the departments of insurance in states across the country now feel empowered and will be empowered to enforce the laws that are on the books, to regulate the PBMs. PBMs have been telling them, you can't regulate me and you can't regulate my claims because those are ERISA claims, or I deal with ERISA plans, employer-sponsored plans. Now that argument for in a wide variety of cases is going to be off limits, and the regulators are now going to be able to enforce laws on the books against these PBMs. So it's immediately effective across the country as of yesterday. All these laws which have been on the books and applied narrowly are now expanded in scope and enforcement. So that's sort of the summary of the impact of this case, and the decisions behind it really have left a roadmap for the way they wrote the decision provides a roadmap for legislators across the country in dealing with PBM reform laws. How do you write them? How do we need to write them in order to fit within the guidelines that the U.S. Supreme Court has written for us? And Scott mentioned they're pretty wide in scope. It is wide, so it's we got a lot of leeway here to play with.
Just to piggyback off what you're talking about too, because in the past, if we wanted to have PBM reform or legislation passed in the states, you almost had to. Well, at least we did Virginia and a lot of other states. Is you wrote in the actual language that it doesn't apply to ERISA covered plans. And so a lot of those current laws that are on the books, I had a conference call this morning with the Government Affairs Committee that I'm on with VPHA and our lobbyists, and we're talking already going through every single one of the laws that we've had passed in the last few years, where ours do specifically say this applies to everybody but ERISA exempt plans. We're going through to remove that for hopefully very quickly, obviously after this, We weren't expecting to have to do that this year. We're trying to squeeze those maybe even in some of our as an amendment to some things. And a lot of states are going to have to revisit their specific language because that's like 75% of the health plans in the state of Virginia. So that's going to open up a whole swath of opportunity to put our thumb down on them for a change.
Absolutely. I think so too. So can we talk a little bit about like the practicality of this? You know, you mentioned, Miguel, that as of yesterday, all of these laws, if they're on the books, like they're immediately effective. Like, what does that really mean? You know, it is how do they get enforced? Because if they weren't effective before, do states have to create some infrastructure? If I've heard, and I don't remember any specific states, but I hear of states passing these laws and then they're kind of like set aside. You know, what does that really mean for, you know, somebody sitting in a state and they know that their state has passed some laws? What exactly does that mean for their pharmacy?
Yeah, so when the state passes a law, it requires the, let's say MAC reform, for example. The PBM is supposed to be responsible to follow the law. But what if they don't? If they don't follow the law, then there's really two avenues to get the PBM to do what they're supposed to do. One is the Department of Insurance of the state is supposed to write them a nasty letter and tell them to comply, or they're going to lose their right to be a PBM in that state. The other is the pharmacy or a patient can sue the PBM in a court and say you're not following the law. Those are the two typical avenues that you can do when the law is not being followed on the books. Up until yesterday, if either one of those avenues had taken place, the regulator would have said, you know what, I'm not sure I can enforce this law against the PBM because they also do ERISA plans. We've heard from some states where they're unable to tell whether a claim is an ERISA plan claim or not. And so they become paralyzed in their ability to go out and try to enforce the laws against the PBMs. The same is true of pharmacies and patients that try to sue the PBMs. They've been faced with a defense where the PBM is saying, sorry, you can't enforce that law against me, it's preempted by ERISA. And so the two basic ways for people to get the PBM to follow the law have been taken away from us up to this point. So as of yesterday, those two avenues that have protected PBMs for so long are now off the books. So now if someone has an existing lawsuit or wants to sue tomorrow, the PBM for failing to follow the law, that defense is gone and they can move forward on these claims. And some of them are very meaningful claims. I mean, with serious monetary damages available to the litigants, so to the plaintiff, the pharmacy. And similarly, we've heard from state regulators in the past that have felt like they can enforce the law on the books. Now that's game on. You know, the regulators are now free to feel like they're devoting the real time and energy and not going to be wasted in going after the PBMs. Because I feel like there's been a lot of regulators that feel a little bit disheartened to say, why should I devote a lot of time and energy to try to go after this PBM when they're just got this ace in the hole? They're going to pull out the ERISA preemption card, and all the time and money and effort is going to be for nothing. So now that's off the books. I think that's going to give a lot of boost to the regulators to enforce these laws that are on the books.
That's really good to hear.
I was just going to say, it also takes away one of the most fun things that I ever had to deal with at a state or federal, legislative subcommittee is, depending on who their audience was, if they're talking to the feds, that's a state's right issue. You can't legislate that. And if they're talking to the states, that's ERISA. You can't legislate that. And it's the same idea. So you can't have it both ways anymore.
No, that's absolutely right. And we have had from time to time, we kind of the global independent pharmacy have had friendly insurance state commissioners that have tried, and kind of like you said, Miguel, they're just ended up spinning their wheels and they get deflated and they no longer try anymore. Scott, from your perspective of kind of understanding and hearing a lot of things, what states out there tend to have like the laws or the things that we should shoot for, or is it going to be like a patchwork quilt that, you know, this pharmacy this state over here has this really good piece of law, and this state over here has this really good piece of law? Like, what does that gold standard law look like now that maybe we should try to go and get in our respective states?
I think that Greg in Georgia's probably got the best, I guess, overall idea of where this probably should go, and look for some more completely awesome stuff to come out of Georgia. You know, Louisiana, because of the independent pharmacy involvement in everything from, you know, school boards to city council to, you know, to their state legislature, because of they've been doing this for 20, 30 years correctly. And so they're set up to really do some, I love saying this, to do some damage to the PBMs. And I tell you, after putting in 50 plus hours a week at my store and then with the advocacy, I really think just because it was such a broad ruling, once again, to me, is the biggest part of the win. Yeah, we could have won just based on the merits of that, you know, particular section of Act 900, but with such a broad ruling that the only thing that we could do to, I guess, just kind of screw ourselves is if we do have too many patchwork state laws, that there might be an ear in the courts for, you know, for the PBMs and the ERISA function of having so many different, you know, laws to have, which, you know, it's kind of what ERISA was supposed to do, is to keep everything kind of on the same plane so it wasn't so complicated. It wasn't really about costs. It was about keeping things uniform and over a set of rules. And we don't really want to give them that type of fodder, because they may win that one if it ever got to that point again. So, you know, those two, I mean, there's Oklahoma, theirs is ready to go, obviously, because theirs was put on hold until this ruling. You know, like I mentioned earlier, Virginia, we're going to have to go back and remove the words except ERISA in a lot of our stuff. But we did that because we wanted whatever 20 or 30% of covered plans at that point could already be ready to go. You know, there's a lot, you know, Iowa, actually, they're pretty progressive with that. There's South Carolina, they're pretty progressive, but I think that Georgia's, you know, Virginia's law is modeled after Louisiana's, because I think it was a little bit more conservative in respect to ERISA. But, you know, going forward, you know, Greg's is the gold standard in Georgia.
So I think that's an important thing to note, is if we do have that patchwork of laws, we are kind of giving the ammunition back to the other side, because, you know, another kind of way that ERISA was trying to do is, like you said, it was trying to make it even, because I could understand from a national company level, if you had wildly different laws and trying to operate in all 50 states, that would become practically impossible. And that was, like you said, that was ERISA's original function, and to kind of flatten those differences. And so I do think it would be important that, you know, we work together and collaboratively, you know, obviously not dependent on one another, but definitely collaboratively, as I think this is going to spark a lot of momentum in state associations and in local chapters of like PUTT and other organizations, but that we work collaboratively. So like, you don't try to make your one state, you know, so much different than somebody else's, because then we're giving back that ammunition to the other side. So I think there needs to be communication and collaboration to make sure that we are all fighting for the same thing, and we're all kind of creating a new level playing field across all 50 states.
Lisa, we have some questions.
Okay, sure, shoot them.
Yeah, do you expect the PBMs will find a way around these rulings?
Yeah, I'll start, I guess. As a lawyer, every case that comes out in an opinion just begs the question about what about the next case? You know, what about the next situation? And there's a petition for appeal in the state of North Dakota's law. North Dakota's passed a really good law a few years back that's also been tied up in the courts. And it has some reforms on mail order, on credentialing, on post-adjudication fees, a lot of things other than MAC. And so I can see the PBMs trying to say, well, those things aren't really like MAC. They're different than MAC in some way. They're going to try to argue that. I think they're going to be unsuccessful in anything that has to do with like post-adjudication fees. That's directly talking about the cost of a PBM for reimbursing the pharmacy. That's right in the wheelhouse.
And that's what I was talking about with the broadness of it, because nothing in their in their brief was talked specifically about this versus that, MAC versus post-adjudication. It just said cost, and if costs increase, then we know that the PBMs are going to pass it. They can do whatever they want to. They can eat it, which we know they're not going to do, or the more likely thing, they can pass it off to the health plan and then ultimately to the patient. You know what? I still have to be paid appropriately with what I believe is a whole other topic that we're not going to get into today, but we also have a right to profit. A lot of the stuff that we're writing or asking of our legislators has to do with making us whole. That's not right. We have to turn that conversation back to, you know what? We are no longer going to ask to be made whole. We're going to ask to be made whole. Plus, we're going to also ask for our right to profit a little bit reasonably. I mean, define reasonably. Well, I just want to be able to pay my mortgage. So, if you can't do that based on the crappy reimbursement, I don't think it's too much to ask. So I think that conversation is okay to have now because we're talking about costs. It didn't single out MAC. It didn't single out anything specific about that. The judges, the justices said basically, you know what? They can pass the cost along. This has nothing to do with ERISA.
So when, you guys have mentioned post-adjudication fees a lot, and, that's a term that I'm very familiar with, but some people may not realize that when we're talking post-adjudication fees, we're talking DIR fees, we're talking GER, anything that happens after the claim, because the whole point of pharmacy and point of sale was you adjudicate the claim, you find out exactly if it's covered, you get your money, and you move on. And all these fees that happen after that adjudication process are what referred to as post-adjudication fees. So I know a lot of people are concerned. Miguel, from a legal perspective, does this help the fight against DIR?
So this ruling will not impact Medicare Part D. So unfortunately, it will not directly or indirectly, as far as I can tell, impact DIRs. I have seen contracts which are starting to incorporate something that looks like a DIR fee in commercial plans.
Yeah.
And so if a state bars these types of things, then yes, this ruling will help that in commercial, but not Medicare Part D.
And then so the next question is, will it help GER or BER or any of these effective rates contracts, which are on the commercial side?
Yes, it will. So the first, you got to have a state law that bans GERs or commercial DIRs in some way, or regulates them in some way. But if you get that on the books, then this ruling will make them enforceable.
Perfect. So that kind of begs the question: how do you get a law passed? I know I learned from some friends, a couple of years ago, a little bit in the inner workings of how you get a law passed. So I'll kind of give my very novice information that I learned that, every state and legislatures, they have access to bill writers, and there's people that's all they do is write bills, and you can give them an outline of the things that you're looking for, or giving them an example of like another state law, and they'll write the bill that's according to their, your state guidelines. And then you need somebody to sponsor it and to, present it to the floor. And so it doesn't take, a whole room of like, law writers to get it done. It can be a fairly, I'll say easy, because I certainly don't know how to write a bill, but for those that do it all the time, it can be a fairly easy process. So can you guys kind of help us understand what, to be able to get those laws on the books, what do we need to do? Like, what are the next steps? If I'm a leader in my local association, if I'm participating in something on a state level, what do I need to do?
Well, first thing is you don't have to reinvent the wheel. Every state that's doing this already has those already written. Now, you may need some help with catering, changing it to your state, based on what you currently already have on the books or you're lacking. But you don't have to reinvent this wheel. But when it comes to the politics of it, get to know your local legislators. I mean, I have a state senator who I've been friends with for years because we do charity work through the local Rotary. And when there was some pretty critical votes coming up on the fly, he's literally texting me what's going on so that I could communicate with, Christina at BPHA, and vice versa, and who we needed to work on and all that kind of stuff. So, the politics of it is you can't be afraid to be, put yourself in a position to be your state or congressman's, go-to for pharmacy. You're the one, when he has a question about pharmacy, I mean, John Cosgrove literally stood up to defend our everything in the kitchen sink bill last session, and he knows nothing about it. He stood up, and this is what he said. He said, I used to work on airplanes. I know airplanes pretty well. I don't know anything about pharmacy, but my pharmacist does, and he told me that this is a good thing. So I go to him when I need something, some advice on an expert in pharmacy. So that's just because of the relationship that I formed with him, and he's been very helpful in that realm. When we got mass faxes out to our constituency the previous year over one of our bills. It came from ATA, and he calls me on the phone. He says, "What's this crap? I'm getting phone calls out the yin yang about people saying vote against this because they got a mass calling or fax from Americans for Tax Reform." He's like, "These people are pissing me off." So like those are the types of information that you get in that process is really it's relationships.
That's a good. I was just going to ask Miguel, does he have any advice for like, if people want to start now, they feel motivated to try and get some of these laws, like what are the best next steps?
Yeah, well, PUTT is a great resource, by the way. I've worked with them here and there for a while now, and they have a great resource of state laws across the country that have worked, and as Scott mentioned, don't need to reinvent the wheel. American Pharmacies, we have the benefit of having a fantastic VP of Government Affairs, Michael Wright. He's got decades of experience in pharmacy and in the work that we're doing in advocacy. And I've had the pleasure of working with him and learning from him. And while what we do when we pass a law can appear somewhat sophisticated, you have lobbyists, you can engage, you can have counsel, such as myself, draft bills. That's all great. It's great to have those resources and to have them to utilize it. And we do that. But for those that don't have access to it, it doesn't mean you're out of the game. I mean, it is simply, what is the problem that you need to get fixed, and you need to find a legislator, typically the one that's your own representative, to get you into the process to figure out how that can be drafted. Every state legislature, every capital has an office that does all the legal drafting for the bill, gets it in the right form that it can actually get into the law books. So if you approach them with a problem, you're likely going to, and you have a representative to be your sponsor, you can get a lot of the steps of the way. Working together is important. Something unique about the pharmacy world, especially independent pharmacy world, is that there is a independent pharmacy owner in every single legislator, representative, and senator's district. They own a business, they employ people in the community, they're part of the community, they're recognized and respected members of the community, and they can, if they act together, they have a huge voice, and it crosses party lines. There is no Republican-Democrat divide on pharmacy. That's something that has been pretty amazing to me. This unanimous decision is a reflection of that. You know, look at all the liberals and conservatives on the U.S. Supreme Court got together and did the right thing, and understood the issues quite clearly, and were able to reach consensus, a unanimous consensus. That's true, and you know, we do a lot of work here in Texas, and there's a lot of conservatives and liberals in the state. They all come together and widely support the PBM reform bills that we've passed here over the last 10 years. So it's a great. The only thing that pharmacy probably lacks up to this point, although that's changing through organizations like PUTT, is the community action. You know, getting together and engaging the grassroots community and saying, okay, we're done with being walked over. Let's now do something about it.
Yep, great job.
Can you guys hear me too? Are you guys okay? Sorry, I fell off earlier in my video.
Yeah,
can you guys hear me okay? Sorry, I just disappeared for a little bit.
No, that's
But,
okay. Nathan.
I'll chime in, and I like what Miguel said. Is yeah, we got to come together, and now is the opportunity to take advantage of that. And if we don't, and we become complacent, then these guys, the PCMA and these PBMs are going to come back and find ways to manipulate this. And this is, if you look at it from, obviously when 8-0, I mean, that was very surprising. I mean, I listened to the Supreme Court case, and honestly, I didn't think it was going to win. I mean, after hearing all the arguments, I didn't think this was gonna be as successful, and it came out of nowhere. But we gotta ride the wave on this and take advantage of it, and to use it as a tool when we're talking to politicians, to your senators, your representatives, and not only using this, but we just had a board meeting through PUTT. And we had a woman who was in the Trump administration, and she was giving us some advice on, how to advocate for pharmacy. And I think she mentioned some really interesting points. And I think one of them was, when you're talking to politicians, you have to bring political pain points. You need to not only talk about the pain of what's going on in pharmacy, but also what's going on with patients. Our drug costs getting too high, our how to bring that, and to bring that address. And we've gone a lot historically to say, hey, we're losing on these reimbursements, and this is horrible, and it's really bad for pharmacy owners. But we need to redefine on how we approach this, and to approach it from I guess, and it sounds kind of drastic, but a political pain point, and to ride this, and use this to our advantage, and not be complacent, and take advantage of these conversations with senators and representatives, and coming together. So.
Good one. Thank you, Nathan. Heather, you had said there was some questions?
I do. Someone asked, do we all just need to lawyer up and be ready to take these jokers to court? Should everybody be doing it on their own, or should we just be patient and collectively get together and do it?
I don't think we should be doing anything on our own ever again. That's one of the things that we've done for far too long in our profession. Miguel is a lawyer. He might have just said yes without thinking about it, but
that's my knee-jerk reaction.
My answer is no, and I mean, maybe that's specific to me because I can't afford a lawyer anyway. That's why I've gotten to know so many I mean, that's the real reason why I do what I do, is just because I get to meet a lot of lawyers and get some free advice here and there. But no, certainly if you've got a case where you think that, you've got laws on the books that have been, or, that continue to get abused, then yeah, absolutely. But, all the contracts with the PBMs nowadays contain arbitration. So good luck.
Yeah, I'll temper my initial knee-jerk reaction of hell yes a little bit in light of Scott's comments, but yeah, as some of them, it obviously, I'll give you the lawyer answer. It depends. It always depends. So there's some cases that you would want to band together and try to do some form of group action or class action if that's available to you. But others you might have, depending on the issue, we might have sufficient damages available to you that you could do it on your own, and maybe a lawyer would take it on even on a contingent fee. So it's so early to tell, and the state of the law is so different in every single state. What's amazing about this decision is it warrants going back and looking at all those claims that we wanted to bring, last year, the year before, but thought or were told we couldn't bring because of this ERISA preemption problem. And so it's now, I think we need to go back and not only examine our laws, but examine the legal cases we thought we might have had. And where we said no last week, we might be saying yes today. So it's definitely, don't go out and hire the first lawyer you see. There's a lot of folks that don't know the first thing about pharmacy, and so that's always a little difficult to try to explain what a PBM is to just a normal business litigator. But I think it is time to starting to use the courts more than we have in the past.
I would say that I've talked to several organizations just in the last 24 hours, NCPA, obviously PUTT and you guys, but there's others that they're locked in rooms right now, like brainstorming and planning and trying to create those action plans for pharmacy. So I think there's going to be a lot of support from a lot of different associations that come out, and that's going to help us either. I know NCPA is always really good at their grassroots stuff, of pre-made templates and letters and things. And, I'm not privy to what they're doing for this, but I know right now they're locked in a room brainstorming on, what is that action plan that they want to start talking about next week. So I think some people are going to be putting together some of those actions. And then we've got a lot of smart people, on this webinar and out in the world of independent pharmacy that I think are going to as well. And I think you made a really good point that past claims and past lawsuits that we either tried to bring or wanted to bring, or that we even lost, they might be worth bringing up again. All that work's already done, but we lost because of this preemptive, or we were, cut short. And so as much as we're all eager, I think we, it's been 24 hours or just a little over, let a little bit of marinating happen and let some of those organizations do that heavy lifting. And then I think it's up to us to carry it that last mile. We can't wait on some organization to do it. I think we're all going to have to put in effort in order, in our own states, in our own backyard, to get it all the way to fruition. So any other questions, Heather?
Yeah, will this impact mail order or the 90-day networks?
Yeah, that's an interesting question. As I said, the court's ruling is pretty broad when it comes to reimbursement issues. And I think that's pretty clear from the court's ruling that anything that has to do with reimbursement, a state law that requires a minimum reimbursement or prohibits a fee, I think that's going to be fair game and not preempted by ERISA. Things that regulate practices of a PBM, like requiring mail order only, or preferring one to the other, or some of these mail order practices, I'm going to predict fairly confidently that the PCMA is going to say that those are somehow distinguishable and different in some way or shape or form. I would never agree with that, but I could see them trying to make that distinction. And so it doesn't have any, the ruling doesn't speak to mail order and those type of preferred practices or required mail order practices. If I were to tell someone whether there's, look at the state law, and if it's saying that a PBM cannot require mail order, my first I'd say you're more likely to win that argument now after this ruling than before. So that they're going to be enforceable. Those kind of state laws will be enforceable.
I'm getting a couple messages on my phone since I had brought up NCPA. A couple of the listeners want to know, what can we do to really collaborate together? Can PUTT and NCPA and other organizations, how can we come together and really put a collective effort together on this? A couple people mentioned like, hey, are NCPA and PUTT going to work together? You know, what do you guys see happening that, you know, you're both from different organizations. You obviously know some of the other players in the world. How can we as a higher level organizations come together to work more collaboratively?
When I took over as president of PUTT, we were a little bit all over the place, and it wasn't because of this organization or anything like that. We were just still trying to find out what that mission is going to look like and where we could fill the void, because it takes a lot of resources to fight this on the federal level, a lot more than it does on the state level. So we kind of agreed that we would leave a lot of the federal stuff to NCPA. Not comparing the two types of organizations. We're very, very different, but we believe we have a role out there. We don't like to necessarily, let me rephrase it in a nice way. We feel like we're fighting somebody that does not deserve our respect or our to be cordial to. So we don't really like to go along with the whole idea of playing nice, because we don't believe that that's what they do. They just have a little bit more money and look a little bit more refined, being evil that they are. The problem is that we don't have a really strong, in every state that is, a lot of those state associations have been affected by membership and leadership issues. You know, the ones that are really successful right now, like Georgia, Louisiana, they have very strong state organizations. And one of the things that we're very clear of with PUTT is that we're not trying to usurp anybody's membership. If you're going to work with PUTT in your state and do something similar like what Nathan did before he joined the board, you know, we encourage everybody to bring in your state organization too. Like, I work very, very closely with VPHA. They obviously are very, they love having me this close to the fight, just from the resources that I help to bring in, the things that I bring to their attention. So I'm not special. You know, this is all stuff that anybody who, you know, has you know, any type of fight in them could learn and know. But, you know, we want these organizations to collaborate based on where we think there needs to be a void filled, I suppose. So for us, we just thought that you know, we could do more on a state by state level based on our membership and who's reached out, and let NCPA provide us some support. I've got very close contacts with you know, some of the lawyers at NCPA that do a lot of the committee and subcommittee stuff, and with the state legislators. So they do provide us support. I don't know how serious they take us per se, but like I said, they can't really ignore us because we're too loud. So
It's that not being nice part. You guys make yourself heard.
I think it's good. It's going to need motivated individuals, and I think Scott did touch on this too, to where you don't want to come off, and I've had conversations with different organizations in the state of Michigan and nationally, to where you have one collective voice. And I think that's important, to where you don't have two individuals coming off with, you know, different opinions about a law that's being introduced, to where you have one voice. And I think that's important. And in our situation, we're a state. We just started a new chapter in Michigan, and I'm sure if anybody who's listening on the line PUTT would be interested in starting a new chapter, a new state chapter also, is what we're trying to do on our board is to get somebody who's a representative from, Michigan Pharmacy Association. There's also the Michigan Independent Pharmacists Association. We're going to represent it from there. So we're gonna collaborate our voices and try to come together, get motivated individuals. And I think if this case should motivate everyone who's a pharmacist, not just independent pharmacists. You're talking community, the guys in the community, guys who are in school, and I think that's another gap that we can get involved too. I did a presentation at a university, and I just asked all the presenters there, all the students in the room. I'm like, do you know what a DIR fee is? There's about 30 kids in the room. One person raised their hand. One person raised her hand in the entire group. And that was because she had worked in an independent pharmacy. So I think that's another gap that we need to fill also is to get into the education, get into where people are getting out, graduating, starting to work, and they're aware of these issues to begin with, so they know. And I became aware of them because I started a pharmacy. I understand it. We see it, and we're a threat to this whole. We're the biggest threat right now to what's going on with the PBMs, and you can see it in advertisements. There's I think every state they have Michiganders. You guys can quote me right. They're on billboards and blaming independent pharmacies for what's happening with drug costs. And anybody who's within this knows that this is clearly not the case. How can you be a threat when you're losing $4 on a prescription and $5 on a prescription all day? A lot of these are not making any money. We're not a threat at all. And I think, I guess I'm getting a little bit off topic here, but
That's okay.
But yeah, sorry, I just had to bring that one up because they're starting to show billboards and it just doesn't make any sense. But
yeah, the first time I seen one, my blood boiled. Like I was like, how in the world are you blaming independent pharmacy? Oh, we're going out of business because we can't afford, as Scott said, to pay our mortgage. And yeah, that's a soapbox for another conversation, maybe in a bar with some drinks.
Absolutely, yeah. I think in conclusion, I mean, with the organizations, it needs a collective voice, and we can't just go off, lone rangers in this effort. We need to come together in one voice, and that's what motivated me about being a part of PUTT. I was frustrated as an owner. I was looking at, I had a drug I dispensed. It was a specialty drug, $9,000. I thought and this is a story everyone's had. I thought I made 150. I ended up losing 550, right? I ended up losing like $3,000. That was my breaking point at that situation. And I'm like, what can be done? What can I do? And rather than just, complain to my wife about it, my kids, they're like, what's a PBM? My 6-year-old's like, what are you talking about, Dad? But I want to take some action. I saw what PUTT was doing. They had great representation in Illinois, and of course, Virginia, all over the country. And I wanted to bring that to Michigan. So I think if anybody's on the line from a different state, connect with PUTT, and of course I'm supporting them. I think they're a great organization. Reach out, and if you want to start an organization with your state, I think now is the best time to do this.
I think we have to share. I think we have to share the experiences. I mean, someone just chatted in that Illinois was doing really great things and had a senator that was proposing a bill that would require PBMs to be fiduciaries. Gosh, that nationwide would solve a lot of the problems with PBMs. And so I think we all need to share. We sometimes know what's going on in our own world, and this is kind of that part where we don't want to patchwork. I think we as the collective, pharmacy owner population, we need to share. We need to be talking and sharing with each other and having those virtual whiteboard sessions. What does your laws have, and what are your senators willing to get behind? And we're going to get some really good ideas from other states, and whether that happens on Facebook or whether it happens in some virtual town halls or something like that. I think open collaboration between pharmacy owners and so that we can go to our senators with some concrete advice and try to do as much of the heavy lifting for them. So it looks like I think we've answered all the questions. Is that correct, Heather? Is there anything else? I want to respect everybody's time. We're getting to the top of the hour. Oh, you're on mute.
I could play by the rules. We do have a few more questions, but we can continue the conversation on our Facebook page, DiversifyRx, at
right.
DiversifyRx.
Yeah, so there was a good couple. Senator Andy Manar was the name in Illinois, and even connecting, talking with your legislator. I think Scott was spot on. It's relationships with those, and they're just people. They're just people. Yes, they have lots of different things, but don't think of them as anything else other than just another person that has a duty and a job, and frankly, they work for you. So, think of it that way. You're really good at, bossing your employees around. So, think of them that way. So I appreciate everybody for joining. Thank you, Nathan, for hopping back on and being able to contribute there. Miguel and Scott, thank you so much for this. Please continue the conversation, whether it's on Facebook, whether it's with your local other pharmacy owners, whether it's your local state association. Continue this conversation. This is just the first of many brainstorming and discussion sessions that are going to be happening. Feel free to follow DiversifyRx. We'll promote anybody's of what's going on. We just want to support the industry. We're a free resource center for pharmacy owners. We're committed to, it's not about money. We're just here to help share resources that are going to help pharmacy owners thrive. So make sure to follow us on all our channels. If you missed any part of the webinar tonight, it will be recorded. We'll put it up on our YouTube page, and we will email out everybody who registered the recording to make it really easy for you so you don't have to go find it. So thank you again to PUTT, to APRx, and to Wellgistics. Much gratitude, and thank you all again to the panelists, and thank you to all of the independent pharmacy owners out there that helped supported this fight, whether you contributed financially or you supported the organizations. Thank you to Rutledge. I heard she's running for governor. Let's just support the people who support us. So congratulations, everybody. This is a big win. Good things are gonna happen. There is a ray of sunshine, and have a great rest of your holiday season, and everybody stay well and stay safe. Thank you so much.
Thanks, Lisa, for having us.
Thank you. Bye-bye.